California's AB5 legal battles are far from over. What's happening in the courtroom? How will the law be enforced? What is the best way to transition? There is a lot to cover. Let's get in the loop with Luke and catch you up. Okay, before we dive into what is going on, let's look at what the law is and how it affects the trucking industry. This law, which is technically now in effect, covers an estimated 70,000 owner-operators in the state. In April 2021, the first injunction, which is basically a pause preventing the law from affecting the trucking industry, was overturned by an appellate court. To put it simply, California's AB5 law is making it more difficult for companies to classify people who work for them as independent contractors with the ABC test. This strict test defines that a worker is presumed to be an employee unless the employer can show that all three of the ABC conditions are satisfied. For the trucking industry, it is the B condition that is causing issues, which says the worker performs work that is outside the usual course of the hiring entity's business, which basically means whether a worker performs an activity that is the core of the business's mission. For example, a trucking company hiring a landscaper to take care of the grounds around a headquarters would not meet the test, but hiring an independent owner-operator would. Okay, so we get it. This is basically either making contracted owner-operators required to be employees or actually have to go fully owner-operator without the help of companies finding loads and being under their authority. So where do we stand with AB5? Over a year of battling in the courts, the case finally reached the U.S. Supreme Court, which declined to hear an appeal of that decision. This meant that in June 2022, the pause for the trucking industry was lifted and the law went into effect for many truckers in the state. But the arguments in the original California Trucking Association's lawsuit have not been fully heard before a court, and they have chosen to continue the legal fight. Then, last month, a few days after the state asked to keep OOIDA, the Owner-Operator Independent Driver Association, to be out of the next step in the lawsuit, a federal district court judge has let the association in. So what's next for AB5? California Trucking Associations is pushing for another pause for the trucking industry, with final briefs due on December 2nd. And after that, the court will decide whether to schedule any hearings. This process will now happen with OOIDA alongside the California Trucking Association, as OOIDA has pushed for more clarity from the law, saying that California hasn't provided any guidance on how they will enforce the law, and it's still unclear how the courts will interpret the law. So the California Trucking Association and OOIDA are in negotiations over their legal rights to try and protect the independent contractor model. Some options that are being discussed include just business as usual and wait and see what law enforcement does. Carriers cancel leases and report drivers as employees. A two-check model where one check is for the use of the truck and another check for the driver. Here, the driver must declare the truck income separately. And lastly, a carrier may become a broker and use owner-operators with their own operating authority. For now, the brokerage model is the most likely solution, but those independent owner-operators would need to get their own authority and insurance if they are now driving under the banner of a company providing those necessities. Going to the brokerage model isn't easy if a company is smaller, since smaller companies with less legal and financial ability are likely to remain non-compliant and face penalties or move to another state altogether. The other most likely option for complying with AB5 is simply making drivers employees. For now, the federal level wants nothing to do with California's strict ABC test. In fact, the Department of Labor issued a notice of proposed rulemaking a few days ago that goes back to a more even test with 6 equal factors instead of California's 3 or the Trump era's 5, with 2 of them being weighed more heavily. OOIDA is looking over the new federal proposed rule, saying it looks promising so far. And this whole saga is complicated, but is vital in how truckers and carriers work together to haul freight and make money. As OOIDA says, any rule must recognize the owner-operator model if it is to be successful when applied to trucking. Truckers are tired of the seemingly endless parade of new classification rules coming from legislators and regulators that have largely left small business truckers and professional drivers feeling ignored. There you have it. You are now in the loop on California's AB5 law. I am sure I'll have more to say in 2023 as the legal fight continues, and you can stay updated on our website at cnsprotects.com. For now, check out these videos on more trucking compliance topics, and a like and subscribe is also nice. Stay safe out there.